Hello and welcome everyone to the main event today. I'm Meeta Sani and I'm really pleased to be joined by our special guest, Anita Kalra. Hi Anita, how are you doing?
Hello, thank you for having me. Really excited to be here today.
We're really pleased to have you here. We've got a lot to get through.
We do, yes, a lot of questions. So excited to give the clarity to everybody here in the room today as well.
Thank you so much. Anita, just before we get into the weeds, we've got 8 or 10 different areas we're going to cover. I'm going to do a little bit of housekeeping so everyone can get the most from this session. So just to say to everyone, as you're jumping in, welcome to the main event webinar. We run these webinars a couple of times a month. Really, it's there for you as employers, people leaders, HR managers to have the right tools to support and get the best out of your people. And right now, with these employment law changes that are coming in, there's a lot to get your head round. And for that reason, we have got nearly 400 different companies in the room. That's our biggest turnout. So it must be, well, it's a popular topic and we know why. So we've got a lot of new faces. So I'm going to do a very quick run through the bit of housekeeping. So this is an interactive session. We make it 45 minutes because we know time is precious. And both Anita and I are going to make sure that you get as much knowledge and information that you can literally apply it back into your world when you get back to your desk. However, if we can't get through it all today, you're going to get a recording at the end, which you can watch again or in double time, share with other members of your team or managers that you think will benefit from the knowledge, and our contact details will be there as well. So relax, sit back, take it in. But my request to you is do interact. As I said, this session is for you. And we've got a chat box here that allows you to comment, question, and just go away with the answers you need. And I've just put a little hello in there to show you how easy it is. So if the first bit of feedback I can get would be just a little hi from you, just to let me know you can hear us, you can see us, and the tech is good, meaning we're good to go. Whilst I'm getting the chat room moving, the other bit I wanted to draw your attention to is we always do a poll, and that's so we can get a temperature of the room today. As Anita has already said, we've got a lot to get through, and there's a lot of changes that are happening, and you know, these are legal changes. This is important we get this right. So the question we're putting to you today is which area of employment law or the employment law updates are at the top of your agenda to embed and understand? We've got day one rights, we've got the probation period management, we've got the increased duty of an employer to prevent sexual harassment. There's a new agency that's going to be overseeing all of this, understanding what the commitment and responsibilities are to the new Fair Work Agency. We've got employment tribunal limits that are changing, and we've got expanded trade union rights. And if there's anything else, just pop it in the chat box, and Anita and I will do our best to make sure that we run through that in the next 45 minutes. So I'm just, Anita, before we get to, I'm just going to have a quick look. Amazing. We've got people from Switzerland. We've got people from all around the country. I'm getting lots of hellos. So that tells me that all the tech is behaving as it should. Anita, thank you so much for being here today. Why is this such an important topic for us to be covering right now?
So there's so many changes taking place in the next 12 months. And as employers, you need to be aware of these changes. So whether or not you're in a capacity as a manager, HR, you need to be aware of these changes and when they're going to take place so that you can plan in advance. You're not planning on the day that these changes take place. You've got a plan in place in advance.
Yeah, it's being ready, isn't it? Because would even you agree that this feels like a lot?
It is a lot. It's even a lot for employment practitioners. So I run an employment law firm. It's a lot for us because actually clients are coming to us and saying, when does this change take place? What do we need to do? And how do we need to budget for the year because of these changes? So like with 0-hour contracts, a lot of hospitality sectors will need to budget accordingly. And changes have to take place fundamentally in employee handbooks and training. So there's always a cost attached to that.
Yeah, that's such a good point, actually, because, you know, when we see the news or new political party comes in, we think about the implications, but it does feel like the SME world has been bombarded with challenge after challenge, new responsibility and new costs. Yeah. And I guess what you've just said about getting ahead of it is probably what's going to help employers to prepare and manage it rather than react and respond in a in a desperate way that might then cost more and create mistakes.
100%. I think the main thing would be to say, don't panic and just create yourself a timeline of when these changes will take place and what you're going to do as a business to ensure that you keep up with these changes. Yeah. So what a lot of my clients have done is effectively done a timeline of when the changes take place. And then internally, what period of time are they going to carry out a risk assessment and introduce these changes? So that could be that they need to provide training to managers, or they need to change policies that they already have in place. But key is definitely don't panic, but just make sure you're aware of these changes because they're coming and they're coming really quickly. So
yeah, well said. We are already, as a talent consultancy, we help our clients on the recruitment, retention and development journey. And part of what we're doing already is talking about how we structure the probation period, how we train managers, what you've already mentioned. And it's good to see that there is a drive to get ahead of it. But one of the things you mentioned, Anita, you're very kindly going to put together a one-pager that is actually going to list all the dates that are coming through and the changes, because they're not all coming on one day, are they?
Yeah, 100%. So these changes are taking place, majority in the next 12 months. So what we've put together is a timeline, which I will circulate with you this week so that you can circulate with everybody that's on the call today. I think that's really important because some of these changes are from the 1st of January and then some are in October, and some of those are already taken place or going to take place in April 2026. So there are a lot of changes, and it's not as easy as they're all coming into play in January 2027. That would have been easy for everyone.
Yeah,
it is a staggered approach, which I appreciate, so that employers have time to understand all of the changes, and it's not too much of a whirlwind.
Okay, right. Well, I think in which case, let's get into it. So you and I were talking in the warm-up about what approach we're going to take, and we decided we're going to stick to the agenda as per the invitation so that we can really give everyone that clear, definitive insight, guidance, and the dates so that they can go away with you know, something solid that they can feel that they're starting to understand. So the first point on the agenda is all around the day one unfair dismissal rights. And it says here that it's the move towards it. It's actually the highest percentage of the poll as well, at 46% of the room. So where do we start with that, Anita? What's happening with day one rights?
I can understand why it's the highest percentage, because this is mostly the biggest change, which is why I want to start on this first. Because at the moment you have, as an employee, you have 2 years protection for ordinary unfair dismissal rights, and that's going to change to 6 months. So it's really important that probation periods and probation policies are reviewed, and that managers have training, because most policies state 6 months that your probation period lasts.
Yeah.
So what I would suggest is that they are revised to 4 months, 3 to 4 months, so that actually when it gets to 4 months, you understand whether or not that employee needs extra time. So they might need an initial 4 weeks. Whereas if you leave it to 6 months, you're very much on the mark of 6 months. You're not going to have enough time. Yeah. So a lot of people say to me, a lot of business owners will say to me, well, actually, I really like this employee, but they need a bit more training. It gives you time to give them additional training if you set it to a 3-month or 4-month benchmark under your probation policy. So if your probation policy at the moment says 6 months, I would revise that to an earlier period. But also it's really key that managers are aware of this. So unfortunately, that's where the mistakes are made. Managers are not aware that probation periods, sometimes not even aware how long that lasts for.
Yeah.
That way, make sure that they're aware of the new policy and what they should do during that probation period. It's really important that it's actively used. And ultimately, if you think something's not right for the business, you will know that quite quickly. You should know that within 3 months. So don't sit on it for 6 months. Be proactive and take steps. But that's the biggest change, that if an employee is dismissed.
Can I just double check the date for that? So when is that coming in, the day?
You do have time, 1st of January 2027. So there is time, but of course you need to ensure that you put things in place now. So give managers training now and look at your handbook. Review your company handbook now. So if you were to make that change now, come January in 12 months' time, it'll be much easier.
Perfect. Sorry, I was just looking at the chat box. Nisha actually just asked when it's coming in. But hopefully, Nisha, you've got that answer now, 1st of January 2027. Very interesting.
Bear with me, just as we're on here. My laptop is saying it's going to die, but I've got it plugged in. Can you give me 1 second?
Of course. While you're doing that, I'm just going to talk a little bit to the room about what we're doing to help our clients with getting managers prepared. And what Anita said about having a 3-month probation period, because at 6 months, you're not going to have any room for error. And one of my biggest pet peeves, or one of my biggest advices that I give my clients, is that have a really definitive probation period plan. So if you've got a 3-month probation period, and this is where we come in with our clients, I guess this is what differentiates, is we don't just recruit, we help our clients embed and onboard, and we actually offer coaching, which we can offer it to you, or you can get your managers to be good coaches. But it's about making sure those people are embedded, making sure that every new employee has really clear, definitive understanding of what the goals are for what good looks like in their role. And as Anita said, you can usually see when people are not performing. And if you have real clarity on what those performance objectives are, it's a much easier process to identify challenges, upskill, and make those decisions as a manager. So that's what we're doing with our clients: management training, really defining an induction and a 3-month goal setting objective structure that then managers can use to record and have the right information, that if it does get to 6 months and you need to let them go from a legal perspective, you've followed process, you've got the data, and it flows easily. Is that fair to say, Anita?
100%. It's making sure that you've got those procedures in place. But you do have until the 1st of January. But the other big thing that's going to happen is that the cap for unfair dismissal is going to be removed as well during that period of time, from the 1st of January 2027. So this is really big. So at the moment, it's set at 118,000.
Yeah.
And whilst the average claim value at tribunal, I was reading this stat this week, is around about 20,000 for unfair dismissal. But for those high earners, people earning over 100K, 150K, during the negotiation stage, such assessment agreements, they're going to be asking for a lot more. So it's really key that actually you have tight policies in place for unfair dismissal now, making sure that you follow a process. So I appreciate that the disciplinary process pursuant to the ACAS Code of Practice can be lengthy, but you'll need to ensure that now post 6 months.
Okay. We've got lots of comments in the group, which isn't surprising on this. So Doris says, what's your advice on for smaller companies where they've got a 6-month probation, they're using it, but they need to find a replacement? Doris, you can come and talk to me about that. We can talk about that separately. Really, it is all about identifying if someone is achieving objectives. I would say if you've got a recruitment partner, build some guarantees in. We offer those guarantees to our clients. For our partnership clients, we do 6 months. So that could all fit into that 6-month probation period. So if you do have agreements with recruitment partners, make sure that probation and guarantees are aligned. Some offer it, some don't, but it's a conversation to have. Sam asks, is it effective for, does that mean it's effective for people recruited from July 26, even though it doesn't come in till Jan 27? How does that work?
So it's effective from, no, so effectively it will be from the 1st of January. So it's anybody that you take on from the 1st of January. So anything at the moment, anybody that you decide to employ between now and the 1st of January, it's not effective, but it is from the 1st of January 2027 from that point of recruitment. They haven't given a lot of detail, to be honest, so we are expecting more details to come out during the year, but from the information provided, it is supposed to be from the 1st of January 2027.
Yeah, that makes sense. And Karina asks about reducing the probation period to 3 or 4 months. Absolutely. That was Anita's first point, that get ahead of it, reduce your probation period. So you've got time to make the adjustments or make a decision. And because even if the notice period goes over 6 months, employees have rights. That's right. Right. So you can't make the decision at 6 months. You'd have to make it at 5 months.
You should make it before, because otherwise you're really leaving it too late. Because actually you might want to give that person an additional time. Also, it becomes complicated where, say, for example, someone's gone off sick and then you're waiting for them to come back from sick leave. So, which is why actually our recommendation is at 4 months, 3 to 4 months, any time between that period. If you stay with a 3-month period, then at least if you're not sure, you can extend it. But I definitely won't set it at 6 months, because if someone goes off sick or something happens unexpected, there's a bereavement leave or anything unexpected, then you're leaving yourself very little time and you're exposing yourself to risk.
Yeah, and remember, as an employer, a probation period really is just a review period. Nobody automatically passes probation. So don't feel that by saying 3 months, you have to decide. You could extend it. But what this is about giving you as an employer the tools to be able to say goodbye to an employee who doesn't fit the requirement when they've started a new position. And for that reason, we recommend that you reduce the probation period and run a really tight ship in that onboarding and induction phase so that you can see if somebody is meeting the objectives of the organization and of their role. So many comments around the date. So it is definitely the 1st of January 2027 at this point. If that changes, we'll update you. You'll get updated. But for now, it's the 1st of January.
At the moment, it's 1st of January, yeah. There's been another change as well, which is the early conciliation period, which ties in with this. So early conciliation actually before December 2025 was 6 weeks. It's now been extended to 12 weeks. So especially for unfair dismissal claims, this is really important. So if an employee decides to plead unfair dismissal, you do now have 12 weeks to conciliate with ACAS. And what we were finding is that the conciliation period wasn't very effective because it was ending too soon. By the point that ACAS were contacting employers, the period was reaching 5 weeks. So you're only having a week to conciliate. So this extra protection has been introduced because of the unfair dismissal right, changing from 2 years to 6 months. But this change has already come into play. It came into play in December 2025. Okay.
So there are so many questions around this because it's not clear how it works in practice. One of the questions we've got, and look, I said that in the poll, the day one rights were 41%. Probation period management is 29%. So that takes the whole room. 70% of the room have this topic as their number one challenge. And so Cynthia is asking, can you extend the probation period to account for periods when an employee is sick, as you can't assess them whilst they are off sick? And is this an issue if you go beyond the probation period? So again, this isn't about the law. This is about applying the law and sensible situations like where does sick leave come into that?
You should really extend the period of time if someone's off sick. So if your policy was, for example, to state 4 months, then you should extend it for a further. It should be extended reasonably for the period that they were off sick, or they were on holiday, or on paid leave, or training, whatever that might be. So if you're in the sector where you've got to do exams and you're on training leave, it should be extended for that period of time. But ultimately, the legislation is going to change. It's going to be from 6 months. So if you decided to extend it because that person's been on sick leave for a further month and it brings you up to 7 months, and that's when you decide to do the probation meeting and you dismiss that employee, they have then the rights to claim unfair dismissal if the dismissal's been unfair. Okay, so where before you would go into a probation meeting and you could dismiss an employee and give them notice at the probation meeting and dismiss them in that meeting after 6 months, the change is that you're going to have to go through the disciplinary policy. So if you decide to dismiss that employee after 6 months, you will have to ensure that you abide by either your internal disciplinary policy or the ACAS code of practice, which is a big change because, of course, if it's a disciplinary issue or a capability issue, then you will need to have a formal meeting.
Yeah. And so essentially, once you're past the 6 months, the disciplinary process comes into play, is what you're saying.
100%, yeah.
Yeah. And some employers they don't need to bring that in, but, most employers want their employees to work out. They've spent time, money, effort, a lot of process to get this person in. No one is managing people out. It's a waste of everyone's time. So we have a phrase, fail. If you're going to fail fast. Yeah. It's better for you. It's better for the employee. But if you can see green shoots of potential, get ahead of it. I think all of the questions on the chat box can be overcome by starting in month 1 and 2 rather than waiting for months 3 and 4.
And the reality is that if someone starts new and then not right for the business, so in terms of values, culture fit, and maybe they've oversold themselves during a job interview, you should know that really quickly within the first few months. Yeah. So it's ensuring that your managers understand this and they feel that they can make these decisions before 6 months rather than leaving it to the last minute. So it is just as important to make sure your managers are aware of this new change as it is for HR departments.
Completely. And I say that actually starts at the hiring stage, having a really clear job description, having real clear employment contract with probation outlined, and not then putting all of that in a drawer, but making sure that you have your touch points with your employee when you revisit the probation period, when you revisit the job description, and again, create some sort of matrix for scoring that you're both committing to and both agreeing to. So there's no surprises, because I don't think anybody wants to come to work and feel like they're failing. I think people want to be guided towards success, and they themselves will know if it's not working out. So it's about going on that journey in partnership, hopefully towards success, but allowing you the time and space to legally let them go without the additional dismissal process before the 6 months. So yes, say 6 months does include the notice period. Cynthia said, can you extend the probation period to account for sickness? I think we've already covered that.
Can I just mention something about notice? So if you're worried about notice and you think, okay, we've just let this employee go at the 5-month mark and their notice is, say, 1 month or 3 months, pay it in notice in lieu. So the termination date then would be at the 5-month mark. Yes, they're not going to be working during their notice period, but try and pay as much as that as notice in lieu, so that their termination date is before the 6 months.
Fine. Understood. So somebody's question commented that this is such a big drop, like from 2 years to 6 months. What do you think is the thinking behind this change?
Fundamentally, it's to offer more employees extra protection. So, of course, in the UK at the moment, there is a big percentage of people not employed. So it's to ensure that people are in employment and that employers are actively using their policies. So I think it's really for employees' protection fundamentally, but it was going to be day one, right? So yes. Actually, we've done quite well because it's 6 months. If it was day one, that would have been very problematic. It does mean there's going to be a lot more claims. There was already a lot of claims anyway at Tribunal, and there's a massive backlog. So just to give you an idea, we've got a client that filed their claim last summer. They don't actually have a hearing date until later 2027. So there's a huge backlog at the moment as well. So it's even more important that you follow policies and procedures, because if you find yourself at Tribunal, there's not going to be a resolution for quite some time. And there's a cost of business in terms of legal fees, instructing matters to counsel. So it's important that you ensure that you've got a policy in place. But yes, to answer your questions, it's for employees. It's fundamentally giving them extra rights. But like I said, it could have been a day one. It could have been a day one, right? So we've not done too bad given it 6 months.
Yeah, we can work with it. As you said, businesses have to get prepared. They have to get ahead. They have to do the training. But it can work to the employee and the employer's advantage. It just gets everyone really aligned, I think, and that's only a positive. The wait and see isn't gonna fare anymore as a strategy, right? It's get on with it and make your decisions quickly.
Make the decisions quickly. That's key.
Yeah. So let's talk a little bit more about day one rights around pregnancy and maternity protection.
Yeah.
What's happening in that space?
So at the moment, in terms of, so there's quite a few changes that are coming into play. The big one is the ban on dismissal during protected periods. So at the moment, what we found is that there's lots of employers making redundancies. There's big restructures going on in organisations, and it's going to be unlawful to dismiss a pregnant employee or a woman on maternity leave, or a lady that's 6 months. She's just returned from maternity leave. So there's a lot of redundancies in the market. So that is going to come into play at some point this year. The consultation ended in January. So it's not come in yet, but the consultation ended in January. And you can only go through a dismissal for special reasons such as gross misconduct. So for example, if you've got an employee coming back from maternity leave and it's special reasons in relating to gross misconduct, then yes, you could go through a disciplinary process. But if it's for minor issues, like such as poor attitude or lateness, then that's not going to be classed as a special reason. So this is quite a big change, because at the moment, I would say we dealt with about 20 clients in 3 months at the end of last year that were all put at risk of redundancy and they were pregnant or just come back from maternity leave. So it's quite a big change that's going to take place at some point this year. So we don't have a date for that yet, but be prepared. is what I'm going to say. And the other special categories that will exist is, of course, if there's a business closure, yes, it would align with under the special categories and you could make a redundancy. Or, for example, if you're going through insolvency or bankruptcy. So it's really got to be a special reason. What it won't consist of is a restructure. So the most common reason for redundancy normally is a restructure, or that the role has reduced or diminished in some way. In those circumstances, it's going to be very difficult. But that consultation ended in January this year. So I do know that the Make Work Pay plan is supposed to come out in relation to this at some point this year. So that's one thing I would say, be careful of, make sure you understand that these extra protections, and if you do decide to go through redundancy, these, of course, the ladies will be protected for that period.
But we don't know what that period is going to be extended.
No, it's not come out. That date hasn't come out yet. So, but it will be unlawful to dismiss a pregnant woman, a woman on maternity leave, or a lady coming back from maternity leave within the first 6 months. So that will occur. It's just when that will happen is an important part. It will take place at some point this year.
And you mentioned about restructure being the sort of main reason why employers use, or the role having diminished in from maybe 5 days to 3 hours. Can an employer still lawfully go through a consultation process and reduce, or is that going to change as well?
So if this does come into play, that the restructure, if it's for reasons relating to restructure or reduced work, which is the main one, then no, you won't be able to dismiss that employee. At the moment, though, the current protections are that if you go through a restructure, or you go through a consultation period with an employee that's pregnant or come back from maternity leave, they have priority over suitable roles. So that came into play early this year. So they get kind of first dibs on that role. It has to be a suitable alternative role and within their skill set. But effectively, they need to be offered the opportunity to apply for that role first.
Yeah.
So if you've got 5 people in the pool for those roles, that individual, being the lady that's pregnant or come back from maternity leave, gets the first opportunity to apply. So that currently exists, and that was a change that happened 12 months ago, and it generally ends at the moment 18 months after childbirth. So that's the current legislation, but the new legislation will be a ban on dismissals during the protected periods.
Okay. And in fact, that hopefully answers Anna's question in the group, asking if there is a genuine redundancy situation, will you be able to redeploy? I guess redeploy is exactly what you've just covered off.
Yeah, I think we don't have a lot of information in terms of the detail for this, other than what the consultation said. So the consultation effectively did say that it will be just for special cases, and they've given a very brief list in terms of what those special cases are. But the special cases were if the business closes down, which is an extreme case, bankruptcy, liquidation. But it did say that a special case wouldn't be if it's a restructure or diminished responsibilities, or the role has ceased in any way. So once we get further information and clarity, I think it will be really important to look out for those. But the consultation only closed in January, just gone. Okay.
And so I've got some questions in the chat box around, does this include adoption leave, shared parental leave? Those are the two questions. How does that align with adoption or parental leave?
At the moment, it's only a ban on dismissals during the protected period. So the protected period is if you're pregnant, on maternity leave, or 6 months during the 6-month period when you return.
Okay.
So if I was returning from maternity leave today, I have protections for 6 months. So it's only during the protected period is what the definition is. So it wouldn't apply, as far as I'm aware, to parental leave.
Okay. So that's where we're at the moment. But when it comes out again, I think we're going to have to do another one of these, Anita.
Yeah, we'll get a lot more detail in relation to adoption leave. But when you look at the consultation paper on this, it's not that extensive because they consulted for a few months to start with, and they wanted individuals to come forward and maybe reflect on their own journeys from employees and employers. So the consultation period has only just ended last month. So I expect it to all come out during the year. But that's a big change because, of course, at the moment, there is a huge amount of redundancies being made in workplaces because of AI and reduction of work.
Yeah, the economy, the market, it's so in flux that, as you said, redundancy is just prevalent everywhere. So employers, be mindful, be aware, get gemmed up, come to webinars like this, talk to Anita, and know where you stand. But in terms of adoption and parental leave, this doesn't apply to that for now.
For now, yes. Watch your space, though. Happy to cover this in more detail when it does come out.
Perfect, thank you. So can we quickly cover bereavement leave rights and pregnancy loss, because that is another new day one right?
Yeah, so it's going to be a day one right from 2027, and you are able to get a minimum of 1 week unpaid bereavement leave, which is before 24 weeks of pregnancy. So actually this doesn't exist for like stillbirths, and so actually it does mean it's unpaid, but it's for 1 week, which is key. So making sure your handbook is updated. That's the quick fix. Make sure your handbook's updated.
Yeah.
And so if a manager is not quite sure what the company right is, they can go to the handbook.
Yeah. You know, on that note, I had a question earlier. Somebody said, I don't think I've ever seen a handbook. Is it a legal requirement? It's not legal, is it? But it's best practice.
No. Yeah, it's not a legal requirement. But if you're in a workplace which is you've got a regulator behind you, then you need to ensure that you have a handbook in place to ensure that you've got up-to-date policies. I personally think it's really key. It doesn't matter how small the business is. If you've got more than 3 employees, you should have a handbook. You can have a smaller handbook. It doesn't need to be as detailed. But also, as an employer, it gives you the confidence to understand what your policies are. So if an employee asks you a question, you can just turn to the handbook.
Refer to it.
Yeah, exactly. You can refer to it. And you can also copy and paste that policy and send it to an employee. If there's a breach of dress code or whatever that might be, holiday policy, sickness, you can just refer them to that handbook.
Yeah, I think it's a great retention tool. And as Anita, as you said, it's about everyone knowing where they stand. Clarity, clear communication. It builds trust and confidence. It builds a great working environment and builds a happy set of employees. Again, if you have questions around that, I'm sure both of us can help you. Reach out. We'll make sure you get, and they're not too expensive either. Like you can put a basic handbook together quite cost effectively, so we can help you with that. Anyone that feels, I don't have that in place right now. Right.
I think sexual harassment was the one that you'd asked about. Yeah, so prevention of sexual harassment by third parties. This is a really big one, and this came into play 24th of October. 2024. So actually, if you're not doing this already, this is something that you need to be aware of. So prevention of sexual harassment by third parties is customers, clients, or anybody that's a third party, which is quite difficult to prevent, especially if you're in the hospitality sector. So if you've got staff that are working front of house or in hotels, it's really key that you've got a risk assessment in place. So my recommendation would be start off with a risk assessment, understand where your risks lie. So you may have team events during the year, Christmas party, whatever that might be. You need to ensure that you've got a risk assessment. Second would be training. Make sure you have training for not just managers, but also employees. So if they're attending a training event during the year, or they're attending the summer social or the Christmas party where the drinks are flowing, they understand what their rights are, but also more clearly, they understand what they can't do, what they shouldn't be doing.
Yeah. And that's such a big responsibility for an employer to show and demonstrate, apart from the benefit that it puts out to the team and the employees. It's important for an employer to be able to show that they've put all these steps in place to take responsibility to prevent sexual harassment, because that's essentially the law, isn't it? That's what's
also, it's like when employees go for a drink after work, where does this lie? So it's important that you've got policies in place. Say, for example, the manager is going with a team of employees on a Friday after work, they're all going for a drink. Do you have a policy in place where employees understand the do's and don'ts, what they're allowed to do? Don't allow yourself to fall in that position. And also, more importantly, make sure you regularly update your policy. So an annual review is just as important. Other things that you could be doing is introducing anti-harassment clauses into supply agreements. So if you've got suppliers that come in that provide training, or they're delivering stock, deliveries, whatever that might be, make sure you've got, it's a quick fix, just put an anti-harassment clause in those supply agreements to offer those safe channels. And it just shows that you're being proactive.
Yeah, that's brilliant. That makes so much sense. And as you said, a quick fix and something that, again, helps employers show how much care and due diligence they've put in place to protect their employees. Does the training, is it for every employee? Is it for managers? Like, who should be trained in this?
I would start off with managers. So last year we provided a lot of training, especially to hospitality, where we provided this to managers, and then we actually asked managers to provide the training to everyone else, because they had to understand what it meant to provide that training to everyone else in the workplace. Yeah. I think it's important to provide this training face-to-face as well, because people are more engaged. But especially in hospitality, I would definitely in the hotel sector. Yeah. I think it still exists if you're home working, because if you have events during the year, such as Christmas parties, the most popular one, that's where the most sexual harassment claims come, is post-December parties. Yeah. But I would say it's key for any workplace, because the uplift of the award is 25%, which is a lot. So an employment tribunal can uplift that award by 25% of compensation, which can be huge amounts of money.
Yeah, and there could be sexual harassment online, on intranet. I mean, even if you're not facing
100%. Yeah, that's key actually. It could be online, and you're right. And also, you've got the change coming into place in relation to NDAs. So this kind of goes into this really, is the rollout is going to be in April this year, April 2026, where you can't use an NDA now for sexual harassment. So if you don't have training in place for managers and key individuals in workplaces, you can't rely on the NDA.
Yeah. And so essentially what employers were doing were, problems would happen, an employee would sign an NDA as part of a settlement agreement, and the problem would go away. That's now illegal. Sorry, did you say that's come in, or that's coming in? The NDA?
That will be from April this year.
So that's literally around the corner.
Yeah. So hate to say this, it means you've got a little bit of time. So if you've got a situation going on at the moment, you could rely upon it. But from the 6th of April, you won't be able to. Because it will be classed as a protected disclosure. So whistleblowing complaints you can't rely upon under an NDA anyway. But the change is that sexual harassment disclosures are going to be classed as a protected disclosure. So it's making sure, again, managers are aware of this change. They may not be aware of this coming in.
Yeah.
And you won't be able to. And if an employer is found to have used an NDA for sexual harassment, what is the breach? Again, it's up to 25% increase of the award if reported. So I know a lot of sectors, such as the education sector, have already revamped their settlement agreements. So of course, I know settlement agreements are utilised in this situation. So if you're using settlement agreements, my advice is to go and review that settlement agreement and the whistleblowing clause.
Okay, brilliant. Thank you for that, Anita. That is so important, because some people, when they're running this process, may not even realise how far-reaching that impact could be. So get your settlement agreements, look at the whistleblowing clause. That's very helpful. So start with management training. That's Anita's advice. Michelle in the group had asked about that. So let's start with that. But I think once a year, a manager should run through the staff handbook and certain policies anyway, face-to-face, giving a handbook and asking them to email to say they've understood it. It's basic, it's not best practice, and it will not hold up as much as if you've spoken to them and walked them through it. So as much as you can.
And also, of course, unfortunately, if I'm going to be honest, the majority of sexual harassment cases are junior employees. So if a junior employee starts midway through the year and you provided the training, say in January, they may not be aware. And it's also just as important to provide safe channels for reporting, because there could be one individual that is targeting, say, for example, junior employees. You need to have a safe channel in place, which is why you need to have a policy, and you need to talk about that policy, which is why it's good to give the training at the level. So being managers and then junior employees, you're better off having every junior employee in the room and providing that training rather than having everyone, because that person could feel uncomfortable if they are unfortunately being abused.
Yeah, understood. And actually, this then comes back full circle to the onboarding and induction process. We make part of that the walking through the handbook and talking about the channels, the policies, the protections, and what's expected as well. So that all falls into place, and having good processes that are documented, again, gives you as an employer peace of mind that you've done everything right, but also that you've informed your employee, and that goes to an advantage for you if something comes up in the future.
Yeah, you have a paper trail to rely on. That you've done the best that you can, and you've understood the new legislation. You've been proactive. That's the main thing. What I would say is you don't want to have a level of compensation of up to an additional 25%. You're better off investing the money now and making sure that everybody understands what the legislation is, and ultimately it's there to protect employees.
Yeah, prevention.
You don't want anybody being sexually harassed in the workplace. So
yeah, absolutely. That's our care and duty to our employees. So get ahead of it, prepare for it. So let's talk about this new Fair Work Agency. Has it come about? Is it coming about? Tell us a little bit about that.
So this is going to be completely new, and actually this is coming into play in April 2026. So it's not far off. And actually, this is going to be a single point of contact for enforcement. So what that means is they have the powers to enforce certain things. First one being is workplace investigations. So this is quite daunting for a lot of employers because they can come in and do an inspection and they can demand certain documents such as contracts of employment, pay slips. What they're going to try to establish is that employees have been paid national minimum wage, they've been paid holiday pay, statutory sick pay, other payments as well, but they will be the main ones.
Okay.
This is, of course, the big thing is to prevent modern slavery. That's the reason behind it.
Okay.
And there has been a big increase in claims at the Employment Tribunal for national minimum wage. So what I would suggest is making sure that managers are aware of this, because it can be backdated up to 6 years, which is a really big one. So if actually you've realised potentially someone's not being paid national minimum wage, you need to make sure that you implement changes now. Because of course, if you have a desktop audit or an in-person audit, so the audit could be on 2 frames, it could be desktop, online, or it could be in person. Wow. You could backdate it up to 6 years.
That could be very expensive for an employer, and hopefully everyone's had the best intentions, but get ahead of it.
Expensive, really expensive, especially if you've just made a genuine mistake. You've genuinely made a mistake somewhere. So carrying out an audit, especially international minimum wage and holiday pay and statutory sick pay is the main one. Okay. Especially in the industry of carers, where you've got carers that could be working overtime. It's really important. But the other big thing that the Fair Work Agency will be able to do, they will be given additional powers after April. We're not fully aware exactly what those additional powers will be, but there will be additional powers. But at the moment, they will be able to bring in a claim on behalf of an employee, which is a really big one.
So they're the agency and they're going to bring a claim? They
would be able to bring in a claim on behalf of an employee. So, which is why I believe that you need to carry out audits now before April. They're not going to start coming into every workplace. How it is likely to work is where there's been a complaint. Okay. So where there's been complaints maybe raised for an employer's not being paid national minimum wage, or there's been some sort of complaint, they're likely to come in and do an audit.
Yeah. Be mindful, everyone. Get ahead of it. Again, I think is the big message for today. Heidi mentions with national minimum wage, salary sacrifice is then an issue. How does that work in practice? So, for example, when employees may do a salary sacrifice, and so their actual payment goes below national minimum wage, how would that?
You would need to make sure that you've got a paper trail in place to say that that's existed. So, of course, make sure you've got it in the employee's file. Make sure you've got an agreement from the employee that this is going to happen as well. So as long as you've got a paper trail, that's key. What I would say you should do is implement that, so the salary sacrifice, in terms of national minimum wage, and you don't have the employee's consent. Make sure you've got the signature on file.
Fine. Again, have a paper trail, have an audit, have notes. You know what? We are coming up fast. We've already hit 12:45. We're coming up to 45-minute mark. But Anita, if everyone's okay, we're just going to maybe just extend for a couple more minutes, because I know we covered the Employment Tribunal time limits, but I'd love to re-summarize on that. I'd love to just recheck the chat box, and I think you mentioned time limits and 0-hour contracts. I think you might have covered those. But Anita, what else do you think that we need to be aware of with these changes and updates that are coming in?
There's quite a lot of more changes, and I would say that definitely I will send out a timeline of those changes and add those additional ones. But another really big one is time limits to bring in a claim. So at the moment, you have 3 months less 1 day to bring in a claim from the last act of discrimination or your termination date. That is going to change from October 2026 to 6 months. So what that means for employers is that an employee has additional time to think about if they want to bring in their claim to an employment tribunal. It extends their period of time. So from 3 months to 6 months. So I know that this is a big one for a lot of employers, because sometimes if they feel that they're at litigation risk, they hold off for 3 months. But this is going to be a 6-month period now, which will mean that there'll be more claims because an employee will have extra time to think about it. It could be that they're out of employment for 6 months and they decide at the 5-month mark, okay, I've been out of employment for 5 months, I'm going to lodge that claim.
Fine.
Okay.
So that is something to be mindful of.
That's a big one, yeah. And then the other one is 0 hours. So of course, there will be a duty for employers to provide guaranteed hours. So at the moment with 0-hour contracts, there's sometimes not ever offered guaranteed hours. And this can be an issue if you've got seasonal workers. So if you've got people working during the summer periods or busy periods, you have to offer guaranteed hours. And how that's worked out, will be worked out, is over a period of 12 weeks. So you look at the last 12 weeks as a waiting period and work out what those guaranteed hours will be. From 6th of January this year, with 0-hour contracts, there is a ban on exclusivity terms. So you cannot say to a worker that they have to exclusively work for you from January 2026. And you have to give reasonable notice from October 2026 if you're going to change a shift or you're going to cancel a shift. So if you cancel a shift last minute, you will have to compensate that employee from October 2026. And this can sometimes happen in hospitality. You could cancel someone's shift that's going to occur tomorrow. That's going to be difficult. If you do cancel it, you'll have to compensate them.
Okay. So again, be really aware. So the 0-hour contracts, when will they be banned from? So currently you're saying have the notice period, but when will they stop being legal?
Could you just say that again? Sorry, missed that.
Yeah, so currently 0-hour contracts have a requirement that you have to give notice if you're changing shifts, but there will come a point that they are no longer allowed to even exist. That's what you're saying?
So they can still exist, but from 2027, you've got to give the guaranteed hours.
Yeah,
so
we can't be called 0 hours.
I would say from January it's going to happen. And actually, this could be the biggest change for hospitality, or if you rely on 0 hours, because you will need to financially manage this. So you need to make sure that your accounts department are aware of this. We've got a large hospitality client at the moment, and actually they're introducing this with managers right now, so they can understand what the financial impact will be next year. Okay. So if you've got, say, 100 employees on 0-hour contracts in a restaurant, which is most typical in London, then you need to ensure that you can work out what are going to be the guaranteed hours. What's
over
the
a 12-week period?
Yeah, over a 12-week period. And you could do that now. It's a lengthy exercise because I'm doing it with a client at the moment, big spreadsheets. But if you work on it now, then you understand what the financial impact will be in January. But the ban on exclusivity terms, which sometimes exist in 0-hour contracts, that's already come in. That's from the 6th of January this year.
Okay. Wow, that was a whistle stop of the employment law changes. Anita, thank you so much. I'm going to quickly look at the chat box to see, because we're already 5 minutes over, but this was a big topic, so I think it's okay. We've got more things coming up in the book. Right, so I think I've got it the other way around. National minimum wage has to be maintained after taking salary sacrifice into consideration.
Yes, yeah.
So I got it the wrong way around. I would say talk to your payroll services, HMRC, look at all of that, double check. But yeah, it's the way you said it, and HMRC updates always have the latest. So that's a great source of information. Anita, thank you for everything today. You have really taken on a big task because there's so much for us to run through. What I would say is that we're going to send out, courtesy of KLG Law, a one-pager of dates. But Anita and I are both here outside of this session as well. We do this session because we want to support and help. But if we haven't been able to answer questions, or you have any area that you want to go into more, our details will come out to you with the recording later today. We're also both on LinkedIn. We would love to connect with you, stay in touch, and go on this change journey with you. But Anita,
thank you for having me, and I will send that timeline across. Again, you can find all these new changes as well on our website, so if you've missed anything, we do have a new article going up this week, which will cover most of these changes I've discussed as well. So
amazing. I will share that with everyone if you can
you.
provide that to us. Right. On that note, we're going to let everyone get back to their days, take all of that knowledge and embed and use it. But we hope to hear from you all. And Anita, I hope we can do this again very soon.
Thank you. Thank you for having me.
Pleasure. Bye, everyone.
Bye-bye.